overview as to what are the basic challenges or how are government lawyers appointed, and then I would encourage Madam Moderator to, if you have any question answers prepared for me, please throw them at me so that we can, engage in a fruitful dialogue for the session. So just to give you a very brief, overview. We have all heard about the Attorney General for India, Advocate General for the states, Additional Solicitor Generals, triple AGs, double AGs, public prosecutors. These terms are very common in a litigation arena in the practice that we entail. I myself have been the beneficiary of representing one state and the central government during my tenure in the profession. So Article 76 of our Constitution provides for the post of Attorney General for India, which is a constitutional post provided in the Constitution of the country. The post of Solicitor General, the Additional Solicitor General are statutory posts, and the proposal for appointment of the SG or the ASGs is generally moved at the level of the Joint Secretary or the Law Secretary in the Department of Legal Affairs, and precisely after obtaining the approval from the Ministers of Law and Justice, and then thereafter the proposal goes to the ACC and then to the President, and the President finally gives the the signature for their appointment. Similar is the role for the Advocate General for the state, which is defined under Article 165 of the Constitution, and the Advocate General for the state is appointed by the Governor. So the terms of the Office of Advocate General are not fixed as such, but the Constitution, does not contain the procedure for the ground of their removal, only for their appointment, and they hold the office normally during the pleasure of the Governor or the President, if the case of Attorney General. It means that, normally if you are not really happy with the officer appointed, you may have to consult the Governor, or if the person who has been appointed feels that the stint has becoming too cumbersome or burdensome, they may also quit their office or demit their office by submitting their resignation either to the government in the case of Advocate General, or if it's the Attorney General or a Solicitor General, then resignation has to be tendered to the President. Conventionally, a person resigns normally when the government or the government in power resigns or is replaced, by a new government after the voting has happened. This is how the trend has been traditionally. So far as the Office of Public Prosecutor is concerned, we must draw attention to Section 24 of the Code of Criminal Procedure. Sorry, CRPC as we popularly call it. And for every high court, trial court, for the central, the state governments, after the consultation with the high courts, they appoint a public prosecutor or a APP, additional public prosecutor, for conducting criminal trials in courts, for prosecutions, for appeals, for any other proceedings on behalf of the central or the state government, as the case may be. Because normally, when you are reading criminal cases, that state versus so and so, but then there are also central government agencies which require public prosecutors. You may have seen in the famous case of Aryan Khan, the NCB was involved in lot many cases of money laundering. Now the ED is getting involved, the Enforcement Directorate or the CBI. At state level you have the CID. So all those bodies also act, and the prosecutor is then appointed to take care of the duties which are being, given to them by the state concerned. Now, I'll just pause myself here and I'll give back the dais to Ms. Gupta. If you have any questions prepared, we can discuss them, or if you would like me to continue speaking, I can speak for 10-15 more minutes and then wait for the audience question and answers.
Yes, so we actually have a bunch of questions, and Avantika would be telling about the same.
Sure.
Avantika, over to you.
Yeah. So before we move on to individual questions, we have some preliminary questions prepared beforehand that was sent to us by the students during the registration process. Just a reminder, till I'm asking the questions to sir, please be sure to type your questions into the chat box. So coming to the very first question, it is regarding the legal aid procedure in India. So the question is that instead of providing legal aid or a legal prosecutor to the clients, what if the government starts giving them money so they can choose the prosecutor as per their wish?
So good question, madam, but it's a tricky question, and I'll tell you why. We already have a Legal Services Act in the country, which provides legal aid in the form of panel lawyers at different district levels, high court level, Supreme Court level, to be given to the people who are indigent or who have financial constraints. There are different level of legal aid in High Court, in Delhi High Court at least. There is a usual legal aid cell. There is also a middle income group legal aid cell which has been inaugurated just a year and a half ago. And look, before we say that a victim has to be given a legal aid lawyer, we have to realize that they're already appointed because it's a state case. Let's say in a case of murder or rape or extortion or any serious crime, the state already has an appointed public prosecutor to represent, the case of the state, to deal with the police personals, to have a constant one-on-one with the investigating officers, etc. So before we say victim, we do not know whether a person who has actually filed the complaint, or the complainant is actually a victim or not till the trial ends. So that becomes a misnomer. I cannot today say that just because a complainant had filed a FIR, they automatically become the victim. For that, they have to face the trial. It may also transpire that after the trial has ended, a person is honorably acquitted, or before the trial has to commence, the charge sheet is filed and a person is discharged because the courts, either the High Court or the Supreme Court or even the trial court at the time of framing of charges, may not find adequate evidence against a particular person. So coming back to your question, whether a legal aid lawyer has to be appointed in addition to public prosecutor, I don't think that is the need. Time and again, Supreme Court has reiterated that a private practitioner can always be engaged. There are times when my office is engaged alongside the public prosecutor in lot many criminal complaints, and we have to assist the public prosecutor. We have to file our wakalatnama on record. We have to take the permission of the concerned court. That we are acting. Post the permission being granted to a private practitioner, and by and large, these requests are accepted. There are lot many criminal matters where my office is actively engaged, on the private side. In addition to the public prosecutor already being there, there are times when a state is filing an appeal, and my client will come to me and say, "We also want you to, stand on the side of the public prosecutor." Giving an illustration from my career when I was representing the state of Rajasthan in Supreme Court between 2014 to 2019, lot many criminal matters were coming my way from the state, and there were times when one of the appellant, or in that case the victim, where the High Court or the trial court had, let's say, given concurrent finding of conviction, or the High Court may have reversed some order, the complainant or any aggrieved party would have hired a private practitioner to also file an appeal, and the state would also become a part in the appeal sometimes. So then it becomes a type of a teamwork, because the state has to have its independent goal in terms of assisting the court from a very different angle. The victim or the complainant or the accused party who may have been aggrieved may engage their own private lawyers to represent them before the court. So this is a regular practice. Yes, legal aid is a very, very important phenomenon. If a person who is an accused, especially I would say an accused, who does not have the financial means to defend themselves properly, then they can request a particular court, and legal aid counsels are provided to them. Every court in the country, be it the Supreme Court, be it different high courts, be it the trial court, have their own pool of legal aid lawyers. They are empaneled. There is an interview process to it. I think if you're young lawyers who are tuned into this video, you can always go on to the legal aid websites of of your particular state organizations, your state body, or your state high courts. And every time there is an opening, I think the tenure is roughly for 2 to 3 years for a legal aid panel counsel. And once the tenure is nearing completion, then I think the new vacancies are floated. So if you are someone who is young, who wants to be a part of legal aid panel, by all means join the legal aid panel. It's a very prestigious post. You get to interact with the judges directly. You get to interact with the clients. If you're a young lawyer, so struggling to build a clientele, then I think legal aid is one of the good stepping stones for you to start your career and have the file marked to you directly from the court.
Thank you, sir. It was quite helpful. Moving to the next question that we received. The first Attorney General of India emphasized that the independent and non-political nature of the position of Attorney General. Among the 14 Attorney Generals that have followed, whether that spirit is still maintained or not.
Right. So I think, look, the spirit is always maintained. We may think, in 2022 that perhaps things are not hunky-dory as they were when the Constitution was framed. But please realize this, that we are living in an era where in every nanosecond we are inundated with a lot of information. And a human brain, by the time we have to compile, assess and analyze that information, we are bombarded with another set of information. And please realize that, be it WhatsApp, be it your news sites, be it your chat groups, be it Instagram, be it whatever social media platform you may be relying on, is a information provided to you for an incident which may have happened. Now, whether that incident culminates into a crime or it culminates into breach of constitutional privileges which have been given to us as the citizen of this country, is something which has to be seen either if there is a public outcry or if there is a case which has been lodged against a particular complaint either on social media or on the instance of social media. So I don't think the ethos of constitutions have been trivialized or they have trickled down. The constitution still remains as robust and as strong, guiding force for all of us today as it was, at the time of its adoption, by the Constituent Assembly and by the government of the country. So I don't think, we have so much to worry because there is a constitution, because we have constitutional courts, the Supreme Court and different high courts, and under those different high courts, different trial courts and other tribunals also functioning in the country. We have responsible number of judges, responsible lawyers, responsible government officers uh, who ensure, that the values which are enshrined in the Constitution are upheld. I'm not saying it's all hunky dory. I'm not saying there is no miscarriages of justice. I'm not carrying. I'm not saying that courts don't carry wrong judgments at times. Yes, it happens from time to time, but majority of the judgments, majority of the verdicts are still applied by the benchmark which has been set by the Constitution. So our current Attorney General for India, Mr. Venugopal sir, is a very eminent personality. He's a very senior member of the bar. He's 90 plus. And he's adorning the post of the Attorney General for India in a wonderful, wonderful way. So I don't think till the time he's there, we have to fear that the Constitution is in trouble or is in disarray. I think he's a very vocal person. He's a very, very senior person in the industry. So is our Solicitor General and other ASGs who are holding the post. It's tough to defend every stance of the government, but I'm not saying that people are tiptoeing on the constitutional mandates, so as to render the judgments unconstitutional.
Thank you, sir. My next question is that is there a difference between representing the government and a private citizen in court?
Yes, there is. Look, for illustration's sake or for example's sake, treat the government as a huge private company. You know, government runs on taxes from people like you and I. And government, just like any other private company, has different branches, different subsidiaries, different ministries, different sub-ministries, and different verticals where the government operates. So to simplify it, when I was representing the government, both at the state level and the central level, I had to deal with different ministries, different bureaucrats, different police officers, with their own sets of problems and challenges. So sometimes, a Ministry of Defense may come to you, sometimes Ministry of Finance may come to you, sometimes other matter may come your way. So every matter which comes to you comes with its own set of challenges. And to simplify it further, when we use the term private client or the government, we are also looking at the benchmark which the people has set for the government. Look, when we say government, it is the elected members in a democracy, people which are chosen by the republic in a very fair and a transparent process called voting or election. So, in a private company, the setup is very different because in a private company, you may float a public sector company or a public limited company or a private limited company. The directors may be limited. It may be more business driven. But the role of a government is the benefit for the people, and their responsibility so far as the nation is concerned is many-folds, because not only are they representing the people of the country, all the verticals which the government has in terms of its ministries and its bureaucracy and other branches, they also have an international role to play when it comes to speaking in terms to other countries and other nationals. So yes, when query or litigation comes to you as a government officer, you have to really weigh the pros and cons as to how you are going to guide or navigate a particular problem. When a private client comes to you, similar questions arises. I don't think your role as a lawyer, be it a government lawyer or be it a private practitioner, really changes many folds in terms of advising a clientele, because you still have to read the law. You still have to understand and interpret the law. You still have to go to the court and argue the case. The only thing is your side changes. If I'm representing, let's say, the government today, then a private practitioner like me would be opposing me. But if I am a private practitioner today, having already spent some time in the government, then I already know what the government lawyer perhaps may be thinking or what their strategy may be. So all in all, I think uh, if you're lucky enough to be in different camps early in your career, it gives you a very good insight as to how to handle litigation. But by and large, I think your job as a lawyer, your job as an officer of the court, to represent the right facts, before the judiciary, before the judge that you're, representing your case, are by and large the same. I don't think, uh, that the government has any lesser ego than a big private conglomerate. I think at the end of the day, it's human beings who are, chairing the post of any minister or any CEO or CFO. So you have to understand where they are coming from, what are the problems being faced in their organizations, and why is it that either they're going to court or they're dragged to court. So those are the things you first have to understand with your clients before making a case in the court.
Thank you, sir. It was quite helpful. Now, the last question that I have is, we have been taught to fight for justice and truth since childhood. But when you get to know that the client or the government you are going to represent is wrong, how do you still pursue that particular case knowing that the party against whom you are fighting in a court is the victim?
Right. I think it's a very innocent question and the right question to ask. Look, every client which comes through a door of a lawyer seldom says that they've either committed a crime or they stand in the wrong. Be it a government, be it a private client, be it a company, everybody wants to have a fair share of their hearing in court. Nobody wants to be held guilty by a court of law or to be indicted in a way in which they lose public face. Having said that, let me give you a few examples from my practice. There are times when I think that a matter has to be put to rest because we know that the government is the biggest litigant in the country, be it the state government, be it the union government. Cases are filed against them and cases are filed by them sometimes. A lot of public interest litigations, a lot of writ petitions are filed left, right, and center. When I was representing the state of Rajasthan and even Union of India for that matter, I would tell the officers who would come to my office to brief me that, look, does this case really need to go to an appeal, or do you actually need to challenge the verdict of a subordinate judge which has come to you? And they would say, sir, if you don't think this matter is worth pursuing in an appellate court, please give us an opinion in writing or speak to our superior. And once I've read my file, sometimes I have given a written opinion that please do not prefer an appeal in Supreme Court, please do not prefer an appeal in a division bench, this matter please do not file a writ. But there have been times where I have told government, let's go and fight this case out, it's a good case, I don't think you have done anything wrong. But when there are cases where I can see a personal vendetta against either a serviceman or in sensitive issues like gender, in forces, etc., we have also had to bear the brunt of the court's anger. So it's not about right or wrong, but at the end of the day, by the sheer measure of your practice and by the experience that you have gained in the profession, have to ensure that the advice that you're giving to the government, as a client, has to be spot on. And you also have to realize that the people who are coming to you from different ministries, bureaucracy, are scared for their jobs. You know, they would not put anything in writing upon themselves because tomorrow an inquiry may be, initiated against them. So lawyer becomes their best insurance. We are their best bet. If we can give something to them in writing after a thorough research, citing good judgments, case laws, and a reasoning, chances are that they can show it to their ministries, to their departments, and then the matter can be put to rest. There are also have been times when, despite my saying, please don't go in and appeal, cases have been filed, they have gone to superior law officers, and it has happened. And again, this happens either because of a difference of opinion or because the department which is pushing the case wants a case to be litigated till the end. So there are different motivating factors, I think, again, individually driven, because when you say government, when you say company, when you say corporate, when you say bureaucracy, who are the people who are behind the curtains? They're human beings, and human beings have a different driving force. It can be greed, it can be ambition, it can be revenge, it can be so many factors. So not everybody has read the constitution, unfortunately, but the understanding of justice really whittles down sometimes. But by and large, I have also come across equally smart bureaucrats, very smart ministers, smart MLAs who understands what a lawyer is trying to tell them, and take the advice sometimes with a pinch of salt, even if they think, it may not, let's say, facilitate their political purpose or political motive, but the legal motive, the judiciary's outlook, outcome, the previous judgment, the wisdom of the court, which has gone down in providing a particular jurisprudence, is also well received by these set of people. So again, it depends from the person with whom you are dealing. It depends with the department who is employed in litigation. So there are these multiple factors that you have to take into consideration, before advising the government. So I'm not saying everybody is guilty. I'm not saying everybody is hunky dory. All I'm saying is every case depends on the facts of each dispute. You have to take the brief. You have to read that brief entirely. You have to understand, and only after you have understood a case properly should you advise your clients.
Thank you so much, sir. It was really helpful. Now, I would like to move ahead to the individual questions that are put into the chat box. So the first question that we have is, could you kindly let me know your opinion on the statement whether or not the Constitution requires transformation?
Madam, your voice is cracking. Could you please repeat the question?
Sir, am I audible now?
Your voice is breaking a little bit. The question is in the chat section, is it?
Yes, sir.
Yeah, sir.
I'm just trying to read the question. Difference between one is different opinion of the statement whether or not the constitution requires transformation. Look, the constitution is always transforming. We have had so many amendments, since independence. And every time you see an amendment, it's because the society is transforming, the society is changing. So transform is nothing but the change, and change is the only constant. So every time there is an amendment, there is a debate in the Constituent Assembly, there is debate in the Parliament. The Constitution, as a living organism, if I may put it, in the simplest of terms, is also transforming, but not in a way which is very drastic. Certain times, at times it is drastic. At times, even the amendments are challenged. At times, the laws which are made are also challenged. The constitutional validity of lot many statutes, which may be ultra vires to the constitutions, are challenged. So yes, absolutely. Uh, Everything requires transformation, and constitution should not be left out of it. But we have heard time and again, I in my law school tenure and you in your law school tenure, that the basic structure of the constitution should still remain the same. The ethos, the principle which govern the legal and the social fabric of the country should still remain the same. So those transformation don't have to be radical or have to be drastic. But if there are things in the constitution which you think needs to be amended, needs to be altered, by all means, there's a parliament which is doing its job, which is pushing the amendments as and when required. So that becomes the transformation stage and the strategy by the government of the day. Ma'am,
Thank you,
I
sir.
think, Ji.
Yeah, thank you so much, sir. The next question that we have is that, what is your opinion on the statement that judiciary is not completely independent nowadays?
Madam, I think it's a misnomer, to be very frank. In fact, I think I was reading the newspaper last week when Justice Ramanna also had to speak on the slide that in certain social platforms there were some dialogues which said that judges are political appointees, or judges are not being appointed in the same way as the ministers who are democratically elected by the people. But if you see, the appointment of judges is again a very tedious and a very meticulous process. If you have to be a judge in a lower judiciary, you have to pass an exam, right? So for exam, it's just like any UPSC entrance or IIT entrance or MBA entrance. It is transparent. Nobody's cheating in that exam to appoint you, or so as to say disappoint you into becoming a judge. You have a very transparent and a fair process. There are circulars which come out for different state judiciary, which tells you that, "Oh, look, this exam is going to happen, and then you are going to have a second round of interviews, or whatever stages there are before you become a civil judge or a magistrate or a senior district judge, etc." So far as the Constitutional Court is concerned, the High Court or the Supreme Court, again, the collegium is already there. The collegium has to nominate the name of people who they think should be elevated to a post of a judge. That has to go to the government, and the government and the cabinet ministers, or the ministers, along with the president, along with the governor, along with the Chief Justice of India, along with the Council of Ministers, with the Ministry of Law and Justice, with IB and RAW, have to look into the character of that person. So it's not that easy. It's not like today, I being the Chief Justice of India, nominate 10 judges and the next day they get appointed. If it was so easy, then every day new judges would be getting appointed in the constitutional courts. But there's a process to it. The government has to nod, either the state government or the central government, depending whether it's the Supreme Court or different high courts. So that really takes time. Are there political motivations? Absolutely. I'm not saying things are devoid of political motivation, but let me explain you in a simpler way. Today you are in a law school, right? You may or may not have a political affiliation. Tomorrow, when you enter into practice, our constitution says who can become a judge. For becoming a judge, you either have to have 10, 20 years of practice standing at the bar. You have to have, you can either be eminent jurist, scholar, etc., to be considered for a post of a constitutional judge. Now, in those 20 years' time, it may so happen that you may have represented different government bodies, be it central government, state government, municipalities, etc. That does not mean that you have a political affiliation. you know and as a person who is donning the seat of a judge in a judiciary, you may have your own personal opinion about a political party or about a political outfit or different things, and every human being or every individual is entitled to have their own opinions. But should that become a bar, or should that become a stage which facilitates a promotion of a judge? I don't think that's right. I don't think that's happening. I think our judiciary today perhaps is more fiercely independent than it was 30, 40, 50 years ago. Look, if the judiciary was not independent, that incident which happened, as unfortunate as it was, when 4 to 5 Supreme Court judges came for a media, bite 3, 4 years ago, when Justice Mishra was the then Chief Justice of India. Those judges had every right, being in the highest court of the country. They were hosting uh, a media trial to a thing. Also thereafter, most of the retired judges do write articles, in newspapers. They do come in webinars. They do speak their mind. They do speak what are the problems of the judiciary. And every system is imperfect. It's not perfect. But to say that the judiciary, is not doing its duty, or it's not independent, or it's in shackle, I think it's a misnomer. As somebody who has been practicing in courts for now 14 years, amongst from Supreme Court to the trial court, I've seen many number of good judges, many number of judges who are fierce in their own independent opinion, in giving justice to people, and that's always an encouraging sign for a young practitioner to, and also as a young practitioner, to tell the society that, look, not everything is dull and gray in the judiciary. There are good judges who give time. There are judges who sit till 6 or 7 in the evening to hear matters. There are bad apples everywhere. Nobody's denying that. But I think the good definitely outweighs the bad in our system.
Thank you so much, sir. The next question put into the chat box says, can you please explain the difference between a public prosecutor and a government counsel?
So I think in my opening comments, I've already explained that that the government counsel, like a attorney general or a ASG or advocate general or a panel lawyer, all these are, two of them are constitutional posts. Every other post is set by the government in consultation with the Ministry of Law and Justice. If you are representing the central government, the eventual agreement or the signature has to be by the President of India. If you're representing the state government, the governor's assent has to be there in consultation with their council of ministers, that again with the Department of Law and Justice. For a public prosecutor, you are representing the state in criminal matters as per section 24 CRPC. If you are for the central government, let's say CBI, ED, NCB, etc., again you can be a special public prosecutor or a prosecutor. So those things are already there. We have already clarified that in our opening comments.
Yeah, thank you, sir. What are the different challenges that a government lawyer faces while representing the government in court? Like,
Well,
are
as I
they
said, Ji.
yeah, are they different from the ones faced when you represent an individual?
Look, both yes and no. When a government is coming to you, government is not a demon. Please understand that. The person who comes to you has same face, two eyes, 2 ears, one nose, one lip, two hands, same limbs. A human being is coming to you as a representative of the government. There may be at times 2 to 4 people sitting in your office, or maybe 10 people if it's a biggish matter, depending on the seriousness of the matter, or what is the challenge which is being put before the court. And a private person, when they comes to you, also comes with their set of challenges and legal issues. So for example, let's say if there is a service matter before the court, where a person who was serving in a government department, or let's say in the defense, or whatever employment that they were constructively engaged by the government, is either suspended, or is not getting pension, or their salary is being not increased for whatever reason, they have an absolute right to go and fight against the government and file a case against the government. Similarly, if the government can satisfy the court that, look, this private practitioner who has come to the court has no ground to initiate this matter, and we have been more than fair, and he has not brought all the facts of the case, and still the judge decides the matter against the government again has an absolute and equal right, just like a private litigant, to appeal those cases. And that's what happens in courts, day in and day out. Sometimes the government is right, sometimes the government is wrong, but at the end of the day, the judges together have to decide and give a judgment on a particular case after hearing both, the government counsel and the private practitioner.
So the next question is, why do you think there is no all Indian judicial services?
Madam, I think too many challenges. Biggest, I think, is the will of the people and the politics involved. I think last month, if I'm not wrong, a rough poll was created whether an all India judicial service would be feasible, and majority of the states, I think, have voted against it, or the bar councils, I think, have not given their consent. Now, factors can be multiple. One factor can be the language factor. That we have so many states in the country, and because the litigation starts at the trial court level, most of the litigants in the country are perhaps not very well versed with it in English. So, if you go to a trial court, let's say in Karnataka, you will see the courts conducting their affairs in Kannada. If you go to Maharashtra, Marathi will be the language. If you come to Delhi, you will see Urdu and Hindi being spoken, at the trial court level. So I think that language perhaps can be one of the barriers to my mind. The other is, I think, the unnecessary opposition. So let's compare the All India Judicial Service, for illustration's sake, to UPSC. You have a UPSC. People from across the country sit in that exam. People from across the country, after having cleared that exam, are given different cadre. You may be a Marathi, but maybe given a cadre, let's say in J&K. You may be a Kashmiri, let's say, but you are given a cadre in Kerala. So I don't think, why can't these things be emulated in judiciary also? The best example is our Supreme Court of India. In Supreme Court, we have judges from all over the country, representing almost every state and the minorities, etc. Now, when the judges are presiding in Supreme Court and the arguments are spoken in English, I have personally witnessed it, that sometimes there may be a litigant who may want to express, their point of view to a particular judge. And the beauty is like this. For example, I'll give you an illustration. Once the hearing was going on, and I think the bench which was presiding was from the northern belt. I think one judge was from Punjab, the other was from UP, and the litigant was, I think, from Tamil Nadu. And the judges said that the group of litigants is trying to address something in Tamil. Is there a lawyer, in the courtroom who can interpret it for us? And again, Supreme Court has lawyers from across the country, and I think 2 3 lawyers who are from Tamil Nadu stood up and translated what they were trying to tell the judges. And such is the nature of justice, and such is the beauty of our country. So as I keep saying that, yes, if things are streamlined, litigants have all the advantage. I'm not saying that litigants have to learn a new language, but the court staff is already there. Don't change the court staff. If, let's say, I tomorrow become a judge with all India judicial examination, and if I have to preside in Maharashtra, but I don't speak Marathi, I only speak Hindi and English, the Marathi speaking staff, who also has a workable language of English or Hindi, can make me understand what the litigant is trying to say. That is number one. Number two, why can't we make all the documents which are filed in the court to be in English? Eventually, all the lawyers who are practicing in the country have gone to a law school or a law college, which means they're well-read people, which means we are the educated lot of the country. So to say that a lawyer cannot speak in English or cannot draft in English is something which really fails me. So I think time has come where we need to collaborate, where we need to join the country together, rather than having a state agenda, or a diversification where we say, look, this cannot happen because there is too much diversity in the country. Yes, we respect the diversity, but what is more important, the diversity or giving people quick access to justice from different board of merit which is prevailing in the country. A person sitting in a remote village in Bihar can be equally meritorious as a person who has gone and studied abroad and maybe perhaps practicing in in Bangalore. So when UPSC can bring the best of minds in the country, why can't the judiciary do it with the All India Judiciary Services? That is my short submission for the audience today. We still have to bring the larger attraction of people to adhere to this mindset and ensure that these things do happen in the future.
Thank you, sir. Your answer was very helpful and insightful. So we have covered all the questions put up in the chat box. You can now please continue with your speech, sir.
So, madam, my speech, I think, by and large, also comes to an end because I think the questions have been wonderful. I think they have made me think, and I think we have almost touched upon almost every point that the guest had, and I spoke at the initial stages of my opening comments. I again would like to thank you for having me here. And I again would like to speak to the audience. If they have any further question, please put them in the chat box. I'm more than happy to answer you for 5-10 more minutes. I know it's a Sunday morning, at least in Delhi NCR, it's raining. It's a weather of having some nice tea and pakoda and not be embroiled in a unnecessary constitutional debate early morning. But having said that, I think whether you represent the government, whether you represent a private counsel, whether you are appointed as an amicus by the court, whether you become a judge, you have a duty towards upholding the basic rights, the basic tenets which have been enshrined in the Constitution of India. That is something we learn, from the day we are in law school to the day we graduate to the day we start practicing, either in a law firm or in a court of law, or in a policy matter, or in a think tank, or in a any other organization for that matter. We try to the constitution lines. I would not say the party lines, but the constitution lines, and just be yourself. I think that is very important. The constitution wants people to be independent, to be fiercely independent in their thoughts, in their notions, in their outlook, in their approach, so that we can uphold the diversity in the country and not divide people on the basis of diversity. I think that is very important.
Thank you so much, sir. So we have received a question which says, a public prosecutor is expected to present a truthful picture of the case before the court. He is not overwhelmingly concerned about the outcome of the trial. He is just there to function as a court officer and ensure that justice is being fairly done. Is this the same in the case of Attorney General?
Look, same in the sense that when we say Attorney General is not just representing the government in a criminal matter, but in an array of important constitutional matters. And when we speak of a public prosecutor, it's by and large in a criminal matter, a white collar crime or a hardcore crime. And it's not that a public prosecutor is not interested in the outcome. They have their own ambitions, they have their own motive to hold the chair of public prosecutor, to represent the state, to ensure that the crime is less in the society, or criminals at least be brought to task in the rightful manner by representing the side of the state. I'm not saying they are doing a disservice to the society. Attorney General, again, being the highest constitutional post, we read about the landmark cases that they're handling on a daily basis, or the highlighted cases, or the biggest cases in which the government is embroiled either with a private company, be it a tax matter, be it a regulatory matter, be it a matter of constitutional mandate. For example, NJC. I remember that Mr. Rodgi had argued it at length for months, before the matter was to be adjudicated. So it's a very tough role being a government counsel. One, because the volume of matters which are coming to your office is huge, right? And you can't do every matter. That's why Attorney General only picks the choicest of matters that their office can handle. Please understand that they also have a limited team of lawyers. They have at best about 5 to 10 lawyers assisting them at a given point in time. And the government being such a huge machinery, have so many matters throwing at the government officers, it sometimes can be uh, really backbreaking. So have some mercy on the government officers. It's not that hunky dory that you think it is. It's very challenging because the next day your matter may be put up for hearing. The judges may not be in a great mood, or the judges may have some bias against the government, or there may be 100 things which can go wrong on a given day. And a court officer, especially Attorney General, has to ensure that they have to keep everybody in good spirit and good humor. Their client, the government, the judges, who are again equally responsible and powerful as the government. So it's a very tough spot to be a government counsel, I would say. Sometimes as a private, you are presenting a private client, it's still easier. But when you are, for the government, fighting another government body, which is the judiciary, sometimes because the judges are going hammer and tongs against you, so you have to keep about your wits and ensure that you do justice to the people. So it doesn't matter whether you are an AG or a ASG or a panel lawyer or a public prosecutor. Enjoy the game. The game is to understand the law, to understand the intricacies of law, and to get justice to the people. And that is eventually, you are a facilitator in the course of justice, not an impediment. And the role of giving judgment is not yours, but of the judges. So that is one less burden on you as an officer.
Thank you, sir. There's a question in the chat box which says, Sir, as a student, how should we study the law or master the constitutional law? How you studied when you were in your law school days?
How I studied. Wow, I would not like to open the Pandora box of going back to my law school days. Look, I was a diligent student, and we all have to stick to our courses. We all have the courses subscribed by the Bar Council of India. Every semester we have to pass certain exams. Yes, in my career, I don't think I've ever picked up a Duggi or a Jhabwala, though I've seen them. I have flipped through those pages, but I always believe read a good book, read good commentaries, read good judgments. They always help you in make up your mind in a better way. They help you understand what is being argued in a court. A good judgment being written by a good judge also gives you a perspective into a judge's psyche as to what they are thinking. Try reading older judgments. Try comparing them with the new judgments which are being written. You can see the difference in writing style, how the thinking in the society has changed. Today, more so in 2022 and going forward, I think you are all blessed to be living in an age where technology is at your disposal. Even when I was an intern back in 2002, when I started my law school journey, though we had Manupatra and we had internet, launched in the country back then, but the speed was not that fast. We still had to, wait for some minutes before we could get a result, on a particular given legal search platform. And I remember in my first 2, 3 internships in a law firm, my seniors would still tell me, please go and start looking at the judgment from 1912 AIR. I belong to that, I would say, generation, which was somewhere in between the elder and the younger generation. We were in an era where internet was there in India, but not as fast as the 4G or a 5G that is about to be launched. Technology was just on the cusp of revolutionizing itself, and we still was required to go to the library and pick up the hardbounds and go through them one by one. And as luck would have it, it always helps you when you're flipping through pages, when you're going to your law school library, when you are going through a book in a physical format. It definitely, I think, helps you register a lot more as opposed to just surfing on the net or being out and about before a computer. Because one, your attention span somewhere gets deflected, because once you're on the net, and if your Wi-Fi is on, chances are you may also be surfing along the side or chatting with your friends. So that continuum keeps breaking. So my advice would be, once you're studying anything, uh, do it with utmost attention and respect. I think that is very important. If you're reading a judgment, have a pen and paper. As you can see, I always keep a pen and paper, or a pencil and a paper with me at all times. A point may strike me, and I make a short note of it. You can make a short compilation. If you have a smartphone that you use, there is a note section in every smartphone. You can start making notes, précis as we call them, of judgments which you think are important to you. I can't tell you which judgments are important. We already have these websites called Bar and Bench and Live Law, which on a daily basis are giving us legal updates, legal news. They also, I think, provide the link, PDF link to the judgments which are relevant, which are latest. Read them, go through them, make short points. It will help you in your law school career in terms of remembering those judgments. And if a question comes to your liking where you can utilize those judgments and answering them in the same platform or a format, then you can definitely score a point or two more than your batchmates.
Thank you so much, sir. Your advice and tips are surely going to help us, not just in our law school life, but also in our legal career. The next question we have is, how to be a part of government council? Is there any direct examination for it?
Look, so it depends. I think the Delhi government had an open invitation for this. But otherwise, for legal aid, I think again you have to keep going to websites. So if you go to the government website of Ministry of Law and Justice of every state central government, you will find different notifications. And those notifications will tell you whether there's an opening for a government lawyer or a panel lawyer or for other standing counsel. So that always helps. Similar things also arise for PSUs. I'm also part of few PSUs. just keep your eyes and ear open. Regularly visit the PSU websites, the Maharatna company, the Navratna companies, etc. Even if you want to be a part of a private company, go to their website, see if in their career column they have an opening, for a retainer to different lawyers. So you just have to be, really uh, aware of your surroundings. I think, if I'm not wrong, these websites like Loctopus and other websites, also Legal Shala, or I think few other websites, also keep updating, young lawyers and law students about different openings. If you're part of a WhatsApp group, a legal WhatsApp group, I think your friends, and your acquaintances also keep floating different PDFs or different openings by different companies or by the government bodies or ministries or municipalities. So just be aware about different openings and start applying to them. Yes, they have different criteria and different credentials. So, for example, the first 5 years are very tough because most of the organizations are looking for experienced lawyers with at least 5 years of practice or 10 years of practice or 15 years of practice. So that helps in terms of, so again, the first 4 5 years you have to be, work very hard. But I think for central government, there's a position called government pleader, which I think requires at least minimum 5 years of work experience, if I'm not wrong, to be appointed as a government pleader for the union government. But otherwise, different organization has a different criteria. Sometimes they may hire somebody with a 2 or 4 year work experience for, matters of smaller magnitude. So just go to these websites, go to Ministry of Law and Justice, see their circular notifications and what opening is being, provided for the time being.
Thank you, sir. The next question we have is, what's your opinion on the matter that a large number of LLB graduates in the country are not in a position to have gainful employment at present, and the number of such lawyers is likely to grow in the future, but Bar Council of India is not decreasing the number of seats in the colleges. My question is, there a need to regulate the number of seats in the law colleges in India to produce good government counsels or counsel in general?
I think it's a very good question. This is something, to be very honest, I think about every day. I sometimes ask myself, what can I do differently to either increase the number of employment in this country for fresh graduates or for the lawyer who are already in the market. Uh, Sometimes I ask myself, what can we do in terms of scalable business to give hope to people. I'm not getting a sometimes the right answer for myself when I'm asking these questions, but there are certain points which I gather for myself and which I would like to share with you also. Look, having more number of law students perhaps may not be the advantage, but if you think we are a population of 1 billion people, it's also not a disadvantage. Our judge population ratio is very poor. Our lawyer population ratio is not very poor, but the quality and the skill of a lawyer that you engage has to go up. And that can only go up when we have quality legal education in the country. That is number one. Number two, there has to be a system which bridges the gap between the lawyers and the trust of people in lawyers and judiciary. I'm not saying people do not trust judiciary, but sitting in Delhi, looking at a metropolitan, or sitting in Bombay or any other metropolitan gives you a different perspective vis-a-vis when you're sitting in a tier 2, tier 3, or a tier 4 city. If you see the condition of trial courts there, if you see the way the advocacy is practiced there, I know a lot of young lawyers who would, having gone to a good law school, would not like to go back to their hometown and practice there. And that becomes a problem because one, they think they cannot change the mindset of the people who are already presiding as judges and lawyers because they have a particular bent of mind. So I think the first challenge to all the young audience or the young lawyers here is, how do you change the mindset of people? How do you instill more confidence in people that at the drop of a hat, with any dispute, they can come to judiciary? It's a multi-pronged problem. One is to decrease the deficit in the trust gap between a common person and a lawyer, and then to improve the number of judges to population ratio. I think these two things parallelly have to be conjoined, and then only a solution can present itself. Otherwise, we can have a number of webinars and brainstorming session, but the real solution is never going to present itself, and that will become a problem. So now you're all young people, you are in law schools. I would encourage all of you to go to your respective district courts, whichever city you come from, whichever taluka, whichever kasba, whichever zilla you come from. Please go there, sit with as many judges and lawyers as possible, brainstorm with them, think about solutions. The change has to start with you. The pandemic has taught us something new, that technology can be used as a great advantage to all of us. And we, as a country which is on the rise, which has so much of youth population in it, if you do not take a step, if you do not today start collecting data, then we will have no answer tomorrow. You know, you have the force with you, you have your batchmates and friends with you, you have your seniors and juniors who are studying with you. Create team of like-minded people, who want to change the country, who want to change the society. लोग कहेंगे ना एक से क्या होता है, एक ही से सब कुछ होता है. If today somebody has to bring a change, that one person has to start somewhere, right? I mean, you don't need a team of 50 people to start with. Even a team of 5 people or 2 people with a similar thinking, similar equation is enough to, bring about a change. And then you have people in the, judiciary to always help you, guide you, navigate you. But please understand, the elder generation always relies on the youth to bring about the change. It's not the other way around. जो जवान आज बूढ़े हो चुके हैं वो बदलाव नहीं लाएंगे, बदलाव हमेशा यूथ लेके आता है. So you are the change, you have to bring the change, we can only show you the path.
Thank you, sir, for answering the question. There's one question that particularly intrigues me. That is, personally, what do you find more satisfying, representing the government or an individual?
Both, madam, to be very honest. You know and if you have a if you're dealing with good people, either on the side of the government or in a private party, who are willing to understand your legal advice, what you have to tell them, who are willing to brainstorm with you at an equal equation, who are willing to obviously pay your fees on time. I think that's always a great motivator. So I think that always makes you happy at the end of the day, and who are willing, to respect each other. If a client comes to me, before I give them an opinion, I also have to understand what is the type of trouble that is lurking around them. If a government ministry or if a bureaucrat comes to me, I have to understand what is the challenges that they are facing in their department, or what is the type of litigation which is staring at them. As I said, I have spent 14 years in the profession now. I have had the privilege of representing different clientele, be it PSUs, be it the government, be it private individuals, be it high net worth individual. And every client brings with itself different set of problems, challenges, and solutions and learnings. So I would not say that my stint with the government has been any less beneficial with my tenure in the private practice. I think they're equally beneficial. You have to be patient when you are a lawyer, both with the government and the government sectors and with the private sectors, because the thinking is very different when you're dealing with different set of clients. So you have to understand their thinking and keep doing the work that you're doing.
So there's a question that do research if it's prepared from judiciary, should they go for LLM or research degrees, or there would be a waste of time?
Sorry, your question is whether research is a waste of time?
The question is that who should go for LLM or research degrees if someone wants to make career?
I understand. I understand. Look, so far as research is concerned, whether or not you choose to pursue a higher degree is entirely an individual choice. I always tell this to people. Second thing is, as a lawyer, as a law student, you can never be far away from research. You always have to research. If you are making a dissertation in your law school, you have to research. If your faculty asks you to make a paper, present a paper, you have to research. If you have to argue in a moot court, you have to research. If you're a practicing lawyer, you have to argue in a court, you have to research. If you have to prepare a pleading, you have to research. So research is something that is inevitably ingrained in our DNA as a law student or as a lawyer. So you can't avoid that. Should you wish to pursue PhD or LLM, that is an individual choice. It depends on after how many years of graduation would you like to pursue your masters. Would you like to pursue masters or not? Are you looking for a scholarship? So there are multiple factors that go into it. So as I said, research, you cannot live without research as a lawyer. Even if you don't like doing research, you will end up doing research on some matter or not. So for this webinar, I'll tell you, my team had researched. Without their research, I would not be able to speak at length. I have not quoted judgments which were given to me on my research note by my team, but they gave me good 10-20 judgments, quoting the different role of AGs and what AGs have to say and what ASGs have to say. But I don't want to inundate people with those judgments because, as I say, you are at liberty to read judgments on your own. But when you hold a webinar, it's also important that what is the USP that a person is bringing to you with their own experience. So that has to be shared so that, the side of practice, which perhaps you may not be privy to at this point in time when you are at law school or when you are just about to graduate, these things will open up eventually when you enter the practice. So the idea is research is a must. Research is a great thing. Without research, lawyers will have no value in the society. So we are very well researched people. In other words, what we call, we are very well read people.
So I totally agree that research is the basic part of being in the law school or a lawyer. The session was really very informative for all of us, I hope. We had a lot of information and a lot of learning from you. There has just come a question. If you permit me, I could ask you that.
Yes, madam, please.
Sir, did the people of India need access to fast justice in today's time? Because so many cases are pending from the 10 to 25 years. The justice system of India is very slow. It gives the right justice, but very late. When justice came, the situation from start to finish has changed, and there is no meaning of that justice.
I agree. I agree. I can't agree more. And as I said, the solution lies with you. Two problems I already indicated: the judge population ratio and the trust of people in lawyers, because the lawyers are the bridges between the people and the judiciary. So that bridge, that solution you have to find. I am grappling with it on a daily basis, as I said. I want the justice system to be as fast as an Amazon delivery service, to be honest. They are the best delivery service. And we trust Amazon being a foreign company because we know that a sanitized, well packaged delivery will come to us for a good price. And we are in a service industry. If we can't deliver this to the people of this country, if we cannot have a last mile delivery of the justice system in the country, me, you, and everybody ahead of us, I think we'll be together and collectively failing in our duty, not just to the constitution, but to the people of this country. So I again urge all of you, brainstorm amongst yourself. I'm always there if you need to pick my brain, to and then can get like-minded people together. Let's try to change the country in a positive way. Look, you are going to a good law school, a great law school. You have everything at your disposal. Ask yourself, what is stopping you? I mean, it's a good question, but the bigger question is, do you have a good answer to this question?
So there's another question. What is your view on Indianization of legal system?
Madam, I don't think our system is too anglicized now. I think we got freedom back in 1947, and उसके बाद तो देसी लोग ही चला रहे हैं देश को. तो अगर एक दो स्निपेट्स आ जाते हैं अखबार में कि इंडियनाइज करना है, आई थिंक इट्स ऑलरेडी इंडियनाइज. जैसे मैंने आपको आंसर में बताया, दैट ऑल इंडिया जुडिशरी सर्विस, I mean, every state has its own language at the trial court level. What can be more Indianized than that? Are our language not Indianized? Are the state languages not Indianized? I think these are very fancy terms used by tabloids and certain people in the media light who just want to stay relevant. I think our system is already Indianized. Look, I am a lawyer. I am a practicing lawyer. I am a proud Indian. If a client comes to me, be it from Dehat, be it from city, be it from tier two, be it from foreign, they are seeking an Indian opinion of the legal dispute to them, and I'm giving them an Indian advice based on my understanding of the Indian law. What can be more Indianized than that? I studied in two foreign universities being an Indian and have taken the best of my learnings, and I've come back to my country, and I'm serving my country. If I'm interacting with a lawyer in Varanasi or in Telangana or in Kerala, they are my fellow countrymen. They're representing the interest of my client or their client collectively in the courts in the language which suits them. Nobody's forcing them to speak English in the trial courts or even in the High Court. So I think our system is already Indianized. What I think the correct way to put this answer would be, yes, we need to Indianize the system by adopting the best values from all the business and the services that we see around us. We see Zomato, we see Swiggy, we see Amazon. We need to Indianize in terms of a faster enterprising in the Indian legal and judicial system by giving a faster access of justice to the people of this country. I think that is what we need to do. That will be the real Indianization and Indianization, of justice. I think that is what is the need of the hour.
Thank you, sir. So Satyanshu would like to say the thanking speech, and I would like to ask her to please unmute herself and.
Thank you, ma'am. Good morning, everyone. So as all good things come to an end, so is the webinar. As I'm going to present myself a vote of thanks and very vote of thanks on behalf of the Society for Constitutional Law Discussion, and I would like to say thank you to all the members who have participated and just a second. I'm sorry, sir. On the behalf of the constitutional law discussion, I would like to propose a vote of thanks to all the participants and all the members who have directly and indirectly contributed contributed to this webinar on the role of government counsel in litigation organized by TSCLD. I would also like to thank Advocate Jayant Bhatt for his insightful knowledge on this interesting topic, and all the members for their participation. Okay. With these encouraging words, I would like to conclude today's webinar. Thank you and have a great Sunday. Thank you, sir.
Thank you so much, ma'am. And before we part ways, I must just encourage all the viewers here that last year, amidst the pandemic, we started a YouTube channel called Sue You Soon. I don't know if all of you have subscribed to it, but please do share it with your friends. I have painstakingly created a legal chat series with retired judges, senior members of the bar, in-house counsels for benefiting young minds and young lawyers. And all these questions which you asked me, I've asked them to try to get a solution. Some of the solutions are really great. I think they can be implemented either by me or by you. So amongst your friend circle, WhatsApp group, please tell them to subscribe to our channel. See you soon. It's only made for a better review and a better legal system in the country. If you have any feedback and comments after watching it, you can always drop me a DM on my LinkedIn profile, and I'll be happy to receive your feedbacks and your comments and how we can collectively get the system in a better situation, better placement, so that people at least in front of us, हमें वकील साहब तो कहते हैं, पीठ पीछे हमें कुछ बुरा भला ना कहें. That is very important. The actual respect comes when people speak nice things about you behind your back. So with that words, thank you so much for this lovely Sunday morning and brainstorming with all the young minds, and I'll be in touch. Thank you.
Thank you for the informative session. Thank you.
Thank you, sir.